Small versus DeOliveira.
Susan. Mr. Thomas, good morning.
Good morning. May it please the court, my name is Thomas Ralph.
I'm sorry, Mr. Ralph.
That's okay. It's
Good
a
morning,
common
Mr.
occurrence.
Good morning, Mr. Ralph.
Thank you, Your Honor. My name is Thomas Ralph, and I'm a Special Assistant District Attorney for Middlesex. Your Honor, it's simply inconceivable that 6-year-old Jane Smith, when speaking behind closed doors to an emergency room physician about the most intimate details of a rape, numerous rapes that she suffered at the hands of her father, could have anticipated that her statements would have been used prosecutorially.
Well, that's a good way to put it, and that fits in with Gonsalves, does it not, where you view it from the point of view of the declarant and what he or she might have thought she was doing when she made the statements? And
That is correct, Your Honor.
Well, it's a question then, isn't it, whether we say that the standard to be applied is an objective one or a subjective one?
Your Honor, I believe that the United States Supreme Court in Crawford said that it was an objective test to be applied. And, of course, in Gonsalves, the question is whether a reasonable person in the declarant's position would have anticipated that that statement would have been used prosecutorially. That is an objective standard. So I would suggest that when you apply that objective standard to the facts in this case, again, it is simply inconceivable that a person in the declarant's position could have anticipated that those statements made to a doctor, dressed as a doctor, wearing a stethoscope in an examination room, would have anticipated.
at what age would a child pass the line under the Gonsalves test, or would it be a case-by-case analysis to determine how sophisticated the child was and so on?
Well, Your Honor, the amicus briefs submitted in this case by the American Prosecutors Research Institute cite a litany of cases or a litany of studies that clearly state that it is impossible for a child under 10 to have the cognitive ability to understand the concept of a trial, of a criminal proceeding, who a judge is, who a lawyer is, to understand what this is that we do.
Mr. Ralph,
we've got mock trials now for kids in elementary school.
I was going to say, Mr.
Goldilocks and the Three Bears.
And they understand a lot of who the judge is.
Turn the television on.
And if you want to, we have 6-year-olds coming in here all the time, and what do they like to do most? They like to sit up here and tell their friends, you're going to jail. That's what they like to do more than anything. This is not a humorous matter, but I think part of what's happened, and which is problematic, is that we take these principles that I think probably nobody was thinking about children when we developed them, and apply them to children, face-to-face confrontation, for example. And, you know, there may be some age differences. 6 is very young in most circumstances, but not in all circumstances.
Yes, Your Honor. I would suggest, again, with respect to the Court's observation that the judicial system is prevalent in our society and the children are exposed to the judicial system. There's absolutely no contest on that. However, if you look at the research that was conducted or compiled by the American Prosecutors Research Institute, it shows that, sure, kids know that there is something called court and there is somebody named a judge. But that doesn't necessarily mean that they understand that a judge decides things. For instance, they might think that a judge's job is to yell at people.
It's to send people to jail is what they understand, I can assure you. Mr. Ralph, help me on this. And maybe this doesn't make a difference. Maybe it doesn't make a difference. But it struck me as I was reading this that if this child had complained of a medical symptom, a rash, pain, and the mother had taken her to see a physician or a nurse practitioner or somebody at an emergency clinic, and in the course of that the child being examined by the medical person out of the presence of the mother and not germane to anything else, had said, this is what, I think, this is what happened. The doctor saying, were you loving yourself, whatever it was. In this case, there's no question that the reason why she was taken, am I correct?
No, there's no question. It's uncontested why she was taken.
Because she made an allegation against the live-in male of the house, the boyfriend, and she hadn't complained of any medical symptoms, correct?
Well, Your Honor, I think that there's a false dichotomy that has been sort of assumed in this case, that there's a difference between a sexual abuse and a medical issue. Sexual assault of a 6-year-old child is a medical issue.
No, I understand that, but I'm just trying to, if you apply the objective test, and once, assuming that we can't simply rule out that all children objectively wouldn't know that something bad was going to happen when they told stories about, I mean, it may not be a trial, but something bad was going to happen to that man.
That's correct, Your Honor, but the standard isn't whether a reasonable person in the declarant's position might expect that something bad would happen. The standard is whether a reasonable person in the declarant's position would have anticipated that the statement would be used prosecutorially.
But I'm worried, I have to say, about 12-year-old children who might well anticipate that it's used prosecutorial, but are now taken because they have been sexually assaulted, or there's a claim of sexual assault, and they're confronting. In other words, it's easier, perhaps, if it's a 4-year-old or a 5-year-old or maybe even a 6-year-old. But children at age 12 may be very knowledgeable about what the bad is, but nevertheless are there seeking medical help or not seeking medical help.
That's correct, Your Honor, and I, of course, would gladly agree with the Court that this is an easy case. The declarant, this declarant, as a matter of law, would not have anticipated that those statements would have been used prosecutorially.
What was the
I
age?
may assume some of these young children, while they might think that, quote, something bad is going to happen, they don't even know necessarily, probably don't know, that what was done to them is literally a crime.
That's correct.
They probably don't know the meaning of crime.
Crime.
That is, if you look at the research that was compiled, that is exactly what the research
So if they don't
holds.
even understand the concept of crime, or whether what was done to them is a crime, they can't possibly even envision this other thing they don't know about, criminal trial.
That's correct, Your Honor.
They may think that the parents might split up or some other ramification will occur to the family, but they wouldn't know that he'd even risk going to jail.
In fact, there's one of the studies actually observed that a significant number of young children didn't understand the concept of court and confused it with the basketball court.
Can I close two loopholes very quickly? The first is, you're not aware of any case before the United States Supreme Court, are you, that deals with this kind of problem? Because we had a case, was going to be on Monday, where we discovered there is one up there on 911 calls. Are you aware of anything?
Your Honor, I believe that the two cases that are pending before the United States Supreme Court are Hammond and Davis, and they both deal with excited utterances in the context of 911
Okay,
calls.
all
I'm
right.
not aware of
All right,
this
fine.
specific
Then
issue.
the second loophole, closed very quickly, is it beyond doubt that this young child cannot testify?
Yes, Your Honor, by both agreement of the parties and finding of the court.
For what reason?
She is simply unable to communicate about this issue. She will run from the courtroom if there are any questions that are asked. She's unable to provide any testimony.
Has anybody thought of taking her deposition, which would not be in a courtroom setting, where she could be cross-examined and so on?
That hasn't been proposed, but again, Your Honor, by finding of the court and by agreement of both parties, that the victim has been declared unavailable. So that issue is not before this court.
Well, of course, the consequences are severe, as I read the case. Now, maybe there's something else that the Commonwealth has, but the whole case depends on the statement of one person who will not be cross-examined.
Well, Your Honor, the victim in this, the defendant in this case confessed. So the only evidence in this case isn't the victim's testimony.
So why are we doing this?
Corroboration.
There needs to be corroboration of the victim's testimony.
Well, certainly there can be corroboration other than Of the victim's testimony or the defendant's testimony?
Corroboration of the
Defendant's.
of the
It
defendant's
doesn't have to
question.
be, as I recall, it doesn't have to be very much.
It doesn't have to be very much.
And
but
you have a medical report here that may be consistent with abuse. You
that
have,
which is arguably sufficient. Defense counsel has filed a motion to dismiss on the grounds that defense counsel believes that that would be insufficient. But whether or not it would be legally sufficient, the fact of the matter is that it is a radically different case when there's some sort of ambiguous physical finding as opposed to a statement from the victim made for the purposes of medical diagnosis and treatment that indicates that she did, in fact, suffer rape.
Mr. Ralph, could I ask
I have a question about how this the very beginning of this. Is this statement contained in the doctor's report?
Your Honor, it's that there are two vehicles by which the statement could be admitted. It is contained in the doctor's report, and the doctor would also be prepared to testify that the victim made the statement.
Well, how can the doctor testify to the victim's statement?
Because it's an exception to the hearsay rule, Your Honor. It's a statement for the purpose of medical diagnosis and treatment.
Well, if it's in his report, yes, but because it would come in under the medical records exception. But are you saying he could just get up on the stand and say what somebody said to him?
Yes, Your Honor. There are two exceptions.
that,
There's a
yeah.
statutory exception for medical records, and there's also a common law exception for statements made for the purpose of medical diagnosis and
Mr.
treatment.
Ralph,
But-
could you help
all
me
right.
on a separate question, which is the following? As I read Crawford again, it seemed to me that one of the things that Justice Scalia and the justices of the Supreme Court were going back to the original confrontation clause and what was meant by that, correct? Am I correct that children were not qualified to act as witnesses at the time of the adoption of the confrontation clause?
That is my understanding, Your Honor.
And what do we do with that?
I would suggest that that further suggests that their statement could not be considered as testimonial. It would simply be, it would have been foreign to the Founding Fathers to have considered this type of statement as the equivalent of testimony. So I would suggest that the original intent, if you follow the Crawford majority's reasoning on it, would lead to the conclusion that the statement was
Wouldn't it
not
also lead
testimonial.
to the conclusion that the Founding Fathers thought they couldn't testify because their testimony would be so unreliable that it wouldn't be worthy of being admitted in court?
Your Honor, that may or may not have been the case. However, the reliability of the statement, of course, can be challenged today. The reliability of the statement is always an issue. It would raise due process concerns if the statement, an unreliable statement, was admitted into evidence. The jurisprudence that has developed since the time of the founding of the Constitution, and particularly with respect to the common law exception to the hearsay rule, holds that statements made for the purposes of medical diagnosis and treatment are per se reliable. That's not to say that a given statement might not be reliable given the specific factual circumstances surrounding that statement.
whose purpose? Whose purpose? The child didn't have a purpose. The child was just told, you've got to go talk to this person. The police met with the doctor beforehand, explained what they were looking for. The examination was done to, in essence, build evidence, forensic evidence for a criminal case that was under investigation. So whose purpose? The doctor's purpose, the child's purpose, the police purpose?
Your Honor, I'd respectfully disagree with you that the purpose of the exam was to build a case, a criminal case. The testimony at the motion to suppress was that the doctor viewed his role as assisting in the medical care and diagnosis and treatment of a medical issue. He did not view himself as being an arm of the state who was
Okay, well, what did he
attempting to
do
collect.
after he examined the child here? Did he tell the police what his results were?
He didn't tell the police his results. However, he is a mandated reporter.
So he reported them?
He reported them, yes.
And in fact, the defendant was arrested right there, in the hospital.
That's correct, Your Honor, but not as a result of the examination. The defendant was arrested as a result of the victim's previous statements to the Department of Social Services worker,
Now,
where she said that she'd been raped.
Now, I understand there were several complaints or indictments brought. All but one had been dismissed, so the only one you're proceeding on is the one where the defendant made an admission.
That is correct, Your Honor. If there are no further questions, the Commonwealth.
Thank you, Mr. Lowe.
Thank you, Your Honor.
Mr. Brennan?
May it please the Court, my name is Michael Brennan, and I represent Marcelo DeOliveira. It's the defendant's position that, in contrast to what the Commonwealth has said, there cannot be the adoption of any kind of child standard or reasonable child standard for the reasons that I think this Court has already talked about. It is inconceivable for a number of reasons, whether you look at the original purpose of the Confrontation Clause, in which I would suggest, as this Court was just asking Mr. Ralph about, that it wasn't a situation where the framers didn't contemplate child witnesses. They thought that child witnesses or people of that age would not be able to testify because their testimony would be completely unreliable. The information that was gathered here came to this particular doctor through a number of sources. There was initially, and if you look at the record, it initially started off as the investigation of a 51A. From the record, it's unclear what the purpose of that 51A was, but the DSS worker spoke with both children at length, and after speaking to Ms. Smith for a period of time said, "Is there any other way that Daddy hurts you?" And she responded by saying, "Yes, he puts his pee-pee here, here, and here," and responds in that way. That statement is inadmissible. The police are called. She gives the statement again to the police, and that statement, under these circumstances, is inadmissible. She's taken from the police, by the police, to the hospital, and I believe it's not contested that this was an acute situation. It was not the kinds of situations that this Court recently talked about as far as whether in Tang or in some of the other cases about securing a dangerous situation or an acute situation.
Well, you say just a minute ago that the statements were not admissible. They're not admissible because they're hearsay.
Correct.
But let's back up. Let's back up to the Sixth Amendment analysis.
Mm-hmm.
Why would they not be admissible, or why don't they pass muster under the Confrontation Clause analysis?
With respect to each of the statements that were made, where the child is unavailable, if the child is available, obviously it's a moot point. We have confrontation. The child can be questioned. Whether or not some of those, and in that case I would even argue that those statements to the other people also are inadmissible under the cases that the courts decided as far as first complaint.
Yeah. Well, they may or may not be admissible under an exception to the hearsay rule.
Correct.
But what is the Sixth Amendment analysis that you say prevents that child, or prevents the testimony of the child from even getting to the hearsay door?
What I would suggest to the Court is that confrontation, as it was expressed in this Court's decisions and as it was expressed in Crawford, they talk about the crucible of cross-examination. They talk about overturning reliability. It's not enough to look and say, well, we think that it's more than likely that this defendant did this, so we're going to allow these statements in, or it's more than likely that these things happen, so they seem reliable. The only test is cross-examination. In this case, the defendant cannot properly cross-examine the person who made the statement. The only thing that's left to the defendant is to cross-examine the person who's now left parroting.
That's all undisputed, but still, the issue is whether the particular statement that the Commonwealth wishes to introduce is testimonial.
Correct.
And if it's not testimonial, then the fact that you can't cross-examine her doesn't change the analysis. It does not pose a Crawford problem, a Confrontation Clause problem, if the statement is not testimonial. How is this statement, or as Justice Spina's questions in it, how would the statement to the mother, I guess was the first one, how would that be testimonial? How would the statement to this doctor, the one they are trying to get in, how would it be testimonial?
I think the issue would be, how is the statement to the doctor testimonial? And I would suggest that it is both per se testimonial in the sense that I believe the evidence is clear on the record that the doctor, at the time in which the doctor was acting as a state actor. It is, I would suggest, it lacks a certain amount of credibility, even though the doctor testified clearly that his primary role, and I believe when he testified to that, his primary role was the care and treatment of the child, but he also testified that he was aware of his role within the system. He understood that he was going to have to testify. He had already been briefed by the police. He understood what he was going to be doing. He also understood that a alleged sexual assault had not occurred recently in time, so that it was not a situation where, as the court asked earlier when the Commonwealth was arguing, where there was a specific medical condition or an acute condition that the doctor was treating.
Let me just stop you there. You agree, or you argue it wasn't a physically acute situation. What about psychologically or mentally?
I don't know that it was emotionally or psychologically acute under the circumstances of this case. It seems that the statement made to the DSS worker and the subsequent statements made to the police and even the statement made to the doctor were almost offhanded comments. And I think getting back to what Chief Justice Marshall said earlier, I don't know that this particular child understood that there was anything even really wrong about what had happened.
Well, just to think about the fact the judge has ruled that the child is unavailable. She
Yes.
can't walk into the courtroom to talk about it because apparently it causes psychological responses. So somehow the child has figured out that this is a difficult topic, and I'm just wondering whether we might not infer that that was a problem for her when she saw the doctor.
Well, I don't think that it would be reasonable to infer that based upon the record before the court and based upon what was testified to at the lower court hearing. There was nothing that indicated that this child was acting out of some kind of emotional pressure, that was acting out of, despite what I would suggest, which is not before the court, some particularly emotional situations involving her mother and some other things.
But did this child have the capacity to understand? Does the record show that this child had the capacity to understand that what she was saying to the doctor would eventually be used in a criminal trial?
Getting back to what I was originally saying, I don't think that any child at that age has the capacity.
So how can it be testimonial?
Because I believe that if you look and apply a reasonable person standard, that a reasonable person...
Reasonable child.
Reasonable person in the child's
And again,
position.
a reasonable person in the child's position. I'm not talking about a reasonable child, but I'm talking about a reasonable person who is similarly situated.
7 years old.
Similarly situated, seems to me, has to take into account some of the infirmities of the person making the statement.
I don't think that that's what Crawford says, and I don't think that that's what this court has held in prior decisions. I would suggest that it's not a situation where you're looking at and applying the infirmities so that, for example, if we're dealing with a person who has Down syndrome, or we're dealing with somebody who has a traumatic brain injury, that we're dealing with a person who cannot, despite their age, could be a 30-year-old person, cannot comprehend the fact that a statement that they make might be used at trial.
When you use the term about reasonable person in somebody else's position, which we have done for such things as statute of limitations, in fact, specifically in sexual assault cases and all that stuff, the court has said you do take into account the circumstances, including the disabilities or infirmities that the person is suffering from, as part of the assessment of what they should have known or reasonably appreciated. Seems to me it's the same here. It's got to be, that someone in the child's position has got to be, i.e., in the position of a 6-year-old child.
Well, again, I would suggest that, as I started off by saying, to adopt a standard which essentially applies a reasonable child standard, I think, is not what Crawford says. I would suggest to the court that what they're talking about is a reasonable person standard, and quite frankly, in my opinion, if a person goes to the police, or let me rephrase that, if a person goes to the hospital having been assaulted or having been raped, not even in the context, I believe that this is an easy case, because I believe given the circumstances that the court is looking at here with respect to the police officers escorting the child and the mother, the police officers advising the doctor as to what's going on, that there's clearly state action and it's per se testimonial.
Mr. Glenn, you may be correct on that, but I want to get back to the competency question. One of the things so the question here is, if you're looking at the original intent of competency, one of the things that happens in in criminal cases, when there's a child witness, it has nothing to do with what she reported to somebody else. It's simply what she saw. There's usually preceded, especially with a child of this age, by a fairly lengthy colloquy by the judge to say that, is this child competent? Does she have the capacity to observe, to see, to remember, to identify?
Correct.
So there's
All of those
competency. It struck me that Justice Sussman's and Justice Spina's questions go to the question when you talk about once you get past its per se testimonial, because this was solicited by the police or by the DSS investigator, or initiated, I should say, not solicited, that you really, this child is a reasonable person in her situation is not competent. So it's not going in for that purpose. It's coming in under a different hearsay exception of medical treatment.
Correct. And again, the other part is, and I'll get to that question, but 23379 is not a blanket statute that permits or always allows the acceptance or the offering of particular evidence. It's within the judge's discretion. So a judge does have the discretion to not admit evidence under 23379, which is one.
I'd like to ask you about the cases from other jurisdictions. The judge below, the motion judge, relied on 2 cases from out of state, which went your way.
Yep.
The district attorney, it seems to me, has done a pretty good job in distinguishing those cases. District attorney has also put forward other cases from other jurisdictions which appear to support the district attorney's position. Do you know of any cases from any jurisdiction that support your position?
I don't know of any other cases other than the ones that were cited. I looked as recently as yesterday, and I have not seen anything that supports. And again, part of the problem is that most of those cases, the cases cited by the Commonwealth and the cases cited by the court, the lower court, and by the defendant, deal specifically with the issue of whether or not it was testimonial, and I take that back, whether or not it was per se testimonial, and not the issue, which is the issue or the question that I'm being asked, which is whether or not it is objectively testimonial, or whether it is whether when you apply a reasonable person test to the same statement, whether it is testimonial under those circumstances. The cases that were cited dealt more with what do you do when a forensic nurse has an interview? What do you do when a doctor who appears and is clearly doing something for the purposes of medical treatment? And I would suggest that this case would be different if the doctor had been responding in the emergency room to a person who was just coming in off the street with a complaint.
But I take it from your earlier question or earlier discussion that if we were to conclude that the standard to be applied is the reasonable person standard in the circumstances of this child, in other words, a reasonable child circumstance, that in the circumstances of this case, this child did not have the capacity to understand or at least the record indicates that this child did not have the capacity to understand that what she would tell the doctor would eventually make its way into a criminal trial.
I think if the court is going to apply a reasonable child standard, that is true. I don't think that this child, when the child gave the statements, the child may have thought that something was going to be bad was going to happen to Daddy, but did not understand that she was going to be ending up in court or that people were going to be testifying.
That's the basis of the Colorado Supreme Court's decision this year, correct?
It is, but by the same token...
frankly, it seems that one, if anything, fits most closely to our existing Gonsalves jurisprudence.
Yes.
The other cases from Minnesota and Nebraska and the Intermediate Michigan Appeals Court really push more towards the the admission of medical evidence that
Correct.
Doesn't frankly help me.
Right. But, and again, I would say that...
And just explain, and I'm sorry to interrupt
that's
you,
okay.
Mr. Bennett, why do you reject that?
What do I reject?
Essentially the Colorado, the justice...
The reasonable child?
Yes.
Again, basically because of what I believe Crawford says, and also maybe from a totally practical standpoint, that it is useless for a defendant to cross-examine the person making the statement. There's no way to Clearly, the doctor is testifying honestly. Clearly, in cases, in other situations.
Yeah, the doctor's simply going to say, this is what she said. Here, in
Correct.
this case, it's actually written into my notes.
Correct.
I asked the child, this is what the child said. Nobody's suggesting that the doctor didn't ask the child that.
And that's true. But again, and again, I know that I'm starting to run out of time here, but in a situation where, in my opinion, my reading of Crawford, I do not believe that Crawford contemplates, or even this court in Tang and Gonzalez really contemplates a reasonable child standard. They're talking about a reasonable person standard, and I understand that it's a person similarly situated or that kind of thing. In my opinion, it's a situation where a person, because I would broaden it, a person going in for a rape kit or a rape investigation, an adult, may not at that particular moment really understand, but should understand under our situation, or a person that goes in having been stabbed understands that at some point their statements are going to be used.
Yeah, I take it from that you have filed pretrial motions that
Yes.
at least implicitly, if not explicitly, take the position that the Commonwealth needs this evidence in its case.
Explicitly, yes.
Okay.
Yes.
Take a break.
If
Thank
there are no
you,
other
Mr.
questions, thank you.
Thank you. We'll take a short break.
All right.